This is a special Waupaca City Council meeting.
Welcome everybody to this special City Council meeting. I call this meeting to order. It is 5:31 p.m. and let's begin with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Take roll. Okay, let's begin with taking roll. Henry?
Mayor Smith.
Here.
Lori Chestnut.
Here.
Paul Hagan.
Here.
Alan Keelan.
Here.
Dave Peterson.
Here.
Paul Mayo.
Here.
Chuck Whitman.
Here.
Jillian Peterson.
Here.
Eric Olson.
Here.
You have 9 present. You have a quorum. Or 8 present.
Math's a little
9.
easy there, Henry.
Counting me.
Yes.
Okay. All right, the clerk's open meeting statement, you have that in front of you, Henry?
This meeting and all other meetings of the Common Council are open to the public. Proper notice has been posted and given to the press in accordance with Wisconsin state statutes, so the citizens may be aware of the time, place, and agenda of this meeting.
Thanks, Henry. And you have an agenda with handouts, and I noticed that I think Mr. Martin also put another copy of this on your desk, so you'll have an extra page, and that came from Dimitri Martin. So we need approval of the agenda. So moved.
Second.
Motion by Keelan, second by Whitman, that we approve of the agenda as printed. Any discussion? All in favor signify by saying aye.
Aye.
Against? Motion carried. I think I'll just, in your packet, Henry had a memorandum in there explaining why we're having that meeting. But again, Henry, I guess we're on radio tonight too, so maybe you could just go forward and explain that.
Mr. Martin has submitted a petition. You might want him to maybe go over the specifics of it. And over the course of about 6 weeks, I've been evaluating it in my office and with some help from the city attorney and some other colleagues. And essentially suggesting that it isn't a proper subject to be placed on a petition, but you need to review it and make some determinations. I think city attorney's heart's ready to, weigh in with any questions you might have. So I'm at the point, I have not certified it, and I appreciate you guys coming together for the special meeting because a deadline crept up on us and I was not aware of it. With referendum questions on Wednesday, if we have anything we want to put on the ballot for a question, we got to get it to the county clerk on Wednesday. And I thought that deadline was a little farther away, that I could just deal with this in your normal meetings times. But we can't. And so today, I have asked that you basically, oddly, take no action. Don't adopt it as an ordinance, and don't refer it for referendum. Take no action. But you need to determine that. Mr. Martin can explain his petition if you feel comfortable doing that. And then I think you should ask questions of myself and the city attorney, because there's some nuances to this thing, this request. So,
John, do you have anything to add to this at all at this time? Okay.
Well, the only thing I would add is that this petition has not been certified, so there really is nothing to act on. The only thing you could act on is if it was certified, then it comes to council. You make a determination as to whether you want to adopt the proposed ordinance or refer it to the election for a determination by the electors. This has not been certified, so you cannot act on it until such time as it's certified. Henry would have to certify it and bring it back to council, then act on it if that's what you determine is proper. I'm not saying that's proper. I'm just saying that you can't act on it tonight.
So,
because it hasn't been certified.
and we can't direct Henry to certify it.
I don't believe you can necessarily.
I suppose I could run up.
You could suggest that he made a bad decision or that his decision should be different. He could reassess that and certify it at a later date, but it's not certified and is not before council for that purpose tonight.
So what is it here? Why are we here tonight? Just to,
Ask Mr. Velker.
Well, I wanted to bring it to you so you're aware of the situation and what he's proposing. And, you know, we can have this conversation. This is on the agenda. It is simply a matter, if you feel that I acted inappropriately, I'll go right upstairs. You recess for 5 minutes, I'll type the letter, and I'll certify it. And they can come back and act on it.
No, you
But-
can't. It's not on the agenda to act on it. You haven't got a certified petition to act on, and you haven't put it on your agenda properly. You'd be in violation of open meeting law. Because you
But it
haven't
says
noticed
petition for direct
You
legislation.
haven't noticed it for that. And your minutes say that you're not acting on it tonight. That's the way I feel about it. If you want to certify it and have another meeting, that's different. Then you'd have to put it on the agenda as action on a certified petition.
okay, so, and it needs to be certified before council can act on it, whether they put it into ordinance form or whether we allow it to go to referendum.
Correct.
But it has to be certified first.
Yes,
Okay. And it's not certified,
it is not.
and even if he certified it tonight, we couldn't act on it.
That would be my opinion, because it hasn't been noticed properly on the agenda.
Okay.
Well, just for my purposes, I mean, I think there's some communities that are putting this to referendum, and they have their reasons, but they certified their petitions, and I've been advised not to certify it. But I wanted, Mr. Martin wanted to get this in front of the council so he could, I think, explain his position. But, this is a little awkward procedure here, but it hasn't been certified. And I've been advised not to certify. By our city attorney and some colleagues, because what ends up, well, we're going to get into the weeds a little bit about how we administer this if it were put in place. We have no mechanism to administer it at our local level. And as a practical matter, people running for city council are not going to be in the business of getting PAC money and big money, to run their campaigns. You all know that. I think they raised the limit up to $2,000 now that you can raise without filing a report. So to put it on referendum and people vote for something that they would expect, if it passes, to be administered, there's nothing to administer. So to me, it's like it's sort of like window dressing. But I guess felt like Mr. Martin was not happy with my decision, and he wanted to talk to elected officials about it. So while you don't take action, you can talk a little bit about it. And if you feel that I've acted inappropriately by not certifying, you could direct me, and I can. Sounds like you might have another meeting tomorrow have to make a decision. So I guess that's where I'm
I'm
at.
not sure we can have another meeting tomorrow either, though. I mean, it's too late to have a meeting tomorrow. We could have one on Wednesday.
Well,
Mayor, we're not here to address the substance of that ordinance and whether it's proper or what Mr. Martin's intentions are or anything else. Basically, what we're here for is to make a determination as to whether the council has authority to act on such a petition. And I told Mr. Velker that this petition was not appropriate because it's an administrative subject to make a determination about such an ordinance. It's not, and the petition for direct legislation has to do with legislation. We have a state law that's in force about this subject, and for us to adopt an ordinance would be an administrative decision by the council. The other problem with it is that the city also does not have authority to act on the subject matter, which has to do with the ordinance that was initially proposed, which had to do with all candidates running for elected office. And the city doesn't have authority to make ordinances concerning all candidates running for elected office. That would be state senators, state legislatures, judges, school board, county officials, on down to city officials. And we don't have authority to make an ordinance that governs that type of thing. We could maybe govern something locally in the city alone, but not local officials, which encompasses lots and lots of people that we have no authority over and have no way to administer anything like that. So we don't even have authority to do this type of a thing under the state law.
Hold on.
And that's where we're at, as to whether we have authority to make, to act. Now, if we wanted to discuss the nuts and bolts of it, that's after it's been certified and whether it's appropriate to adopt that ordinance or submit it for referendum. But that isn't what we're here for tonight. We're here to make a decision to put a blessing on Henry's, or not, on Henry's decision that says that he's not going to certify this because it's not appropriate.
And we can't even make, officially, we can't even make an emotion on that. It's just in
Right.
discussion,
Right.
right? Okay. Dimitri, relax just a second here, so I understand what we're going through here.
Might I ask a question, please?
Yeah, go ahead.
So this petition is not exclusive to city aldermen, but seeks all officials in the city jurisdiction? Is that-
That's what it says. It says all candidates running for elected office. It doesn't say city office, it says elected office.
Okay.
And that has to be submitted to the council the way it's set forth in this petition. Unaltered is what the statute says. And so we don't have authority to act on that. We can't make ordinances that would govern candidates running for county offices or any other office. And I believe it includes it if it says elected office.
Thank you for pointing that out. I did not catch that.
Go ahead.
I'll try. My voice is real bad. I thought there was a second letter or notification in our packet where Mr. Martin adjusted it to say city officials, or he added the word city to several paragraphs and tried
Yeah,
to
this-
counter that a little bit. That's all-
Yeah,
that's all
this-
I'm
He's
saying.
not-
Where did that go?
He's not entitled to make that type of an amendment. There is a provision in there that says they can do some housekeeping on these things to make a determination, but as far as what was presented, it has to be acted on unaltered. For him to change that portion of the petition on his own initiative would not have necessarily been signed by the 409 people who signed it. That isn't what they signed. They signed elected office. They didn't sign anything about just city officials. And if he wants it to be just city officials, I believe he has to go back and recirculate it with that wording in it and then present it for that one particular change. But he can't just change it and decide that it's going to be whatever. Right.
Anything else? Okay.
I would like to chime in there on something. I've run for re-election twice, and I've spent $0 on my campaigns. All I did was put in some time gathering signatures on my petition. So I haven't spent anything, and I think this is a non-issue. I don't see this as pertinent at all to what we're doing here.
I was thinking about that too, Alan, on the way here. In 21 years, I've had 2 donations, and both of them were from city residents.
Although, well, we can get into the detail even more on that, but, I mean, were those city residents within your ward?
One. One was, one wasn't.
Okay, so, I mean,
Yeah.
the point is there. But the real question is that from what I understand, from what the city attorney is saying tonight, is that it's not certified. If it was certified, we have an either-or option here. We either have to enact an ordinance if it was certified, now correct me if I'm wrong.
Correct.
Or we have to put it to referendum
Yes.
if it was certified. But it was not certified.
Correct.
And so we can't do either, is what you're telling us.
Yes.
Mayor, where does the deadline come in? What does it apply to? Does it apply to referendum or ordinance? Or both?
Referendum questions.
Okay.
Because the statute says next election, so that's April.
So if we wanted to make it an ordinance, there is no deadline. We could just come back next month if you decide to certify it. All right.
Yeah, I guess the referendum would be out of the question then, obviously, because it would be beyond that.
Well, it wouldn't be out of the question. It would be out of the question for this next election because it would be too late to get it on the ballot. However, whatever the next election after that is, it would be referred till then for referendum.
Okay. Okay. All right. Any other questions? I want to make sure you're clear on what we're talking about here. Dimitri, just introduce yourself, please, and give your address for the record.
My name is Dimitri Martin. I live at 817 Sunridge Drive here in the city of Waupaca. There's been several points, and I've done my best to try and keep track of them so that I can respond to each accordingly. With regard to the clerk and his duties, I would direct your attention to State Statute 9.20, sub 3. And it says in the first sentence, the clerk shall determine by careful examination whether the petition is sufficient and whether the proposed ordinance or resolution is in the proper form. That's it. 2 obligations. It doesn't matter whether he likes it. It doesn't matter whether he thinks it makes sense. It doesn't matter whether he thinks it's constitutionally valid. That is beyond his authority. It is beyond his authority to determine whether it is administrative or legislative in nature. That is not the clerk's role. The clerk looks for 2 things. Sufficiency, does it have the required number of signatures by citizens within the city? And 2, is it in the proper format? If it's not meeting either of those 2, I have 10 days to amend it to get it into that proper format, and then the clerk is bound to present that to the council. The clerk has been derelict in his duties because the clerk had 15 days to get that certification to me. I had then 10 days to respond to the objections of proper form. I'm assuming everything it's the only thing that he could object to because he did ratify that the number of signatures were sufficient. So I did respond to that. And then after that response, by state law, later on in that statute, sub 3, it says that he has 30 days to present that to the clerk or to the council. Now, it has not been presented to you, and so here we are at this late hour trying to cram it in. Now, I threatened to file a petition for a writ of mandamus because Mr. Velliker was not following state statutes. And I called the administrator of the Wisconsin Elections Commission, Mike Haas, who is an attorney, and he told me the same. The clerk has no right to be delaying this unless it's not in proper form. So here we are today because, thankfully, the administrator of the State Elections Commission called Mr. Velliker and explained to him what his role and what his authorities are. Now, it is up to you, the council, to take this legislation, which is in proper form and which has sufficient signatures. Therefore, it does need to be certified by Henry. That's the law. So it's further the law if you look under state statute 60 something, I can pull it for you, 67 or 4 or something like that, where they talk about the statutes for a city, that the mayor's responsibility is for ensuring that all municipal officials follow the state statutes. And so the mayor has the right, if not the authority and the responsibility, for having Henry Velker go upstairs, preferably right now, and draft up that certificate and give it to you so that you can vote on it. As a matter of fact, it says later on under sub 3 that when the amended petition is found to be sufficient and the original or amended ordinance is in proper form, those are only 2 criteria, the clerk shall state so on the attached certificate and forward it to the common council or village board immediately. Well, there's nothing more immediate than going upstairs right now, putting that together and bringing it back down here. Now, I don't see anything in this agenda that precludes Henry Velker from going upstairs and bringing that petition down here. So I don't think it makes any sense. I don't think there's any legal grounds for an opinion that he does not have that right. Now, in terms of whether it's administrative versus legislative, that is a subject that the city council, you, city council members, have the right to discuss. Not Henry, you. Now, Henry has sought counsel on that, and I can tell you that I have sought counsel on that. I have talked to Mike Haas, again, the administrator of the Wisconsin Elections Commission. I've talked to Jen Miller, who is the attorney for United to Amend here in Wisconsin. I have talked to Emily, I can't remember her last name, but I've got it in my records, I can get it to you, of Citizens Action out of Washington, D.C. And I've spoke with Robert Forseth, the local attorney. And they're all telling me the same thing. This is indeed legislative. As a matter of fact, if I can draw your attention to the case law following sub 8 under 9.20, it states the various findings when this has been challenged. And one of the findings does pertain to whether it is administrative versus legislative. And you will note that that is in State versus Althouse, which I happen to have a copy of right here. And if you were to review this, and I can pass it around, it gives the guidelines as to what is legislative and what is administrative. And I'll read that. In reference to what constitutes legislative and what administrative action in connection with registration of the power of initiative or referendum to legislative matters, it has been said that actions relating to subjects of permanent and general character are usually regarded as legislative. This is a permanent ordinance that is being proposed. And those providing for subjects of temporary or special character are regarded as administrative. This is not a one-time deal. This isn't saying that we want the police department to have a new building or something. This is an ongoing ordinance. This is legislative. It goes on to say the power to be exercised is legislative in its nature if it prescribes a new policy or plan. That's what this does. Whether it's administrative in nature if it merely pursues a plan already adopted by the legislative body itself. Now, I've read through the city of Waupaca's ordinances, and there is no ordinance that you have that stipulates how candidates in the city running for elected office can or cannot receive contributions. So I'm not trying to change a local ordinance. There is no ordinance. This is legislative in matter, it's permanent, and the case law will prove to that effect. And if you were to read further into the case law, you can see that this was challenged again in a different municipality. It was challenged in the case law under the in Mount Horeb. And I can read from you there, but it's basically referencing, again, what I just read to you as to what is legislative and what is administrative. It's very obvious. Anyone who understands or reads through this This is clearly legislative. Administrative would be like saying, you know, if we're going to enforce this other ordinance that we need to follow a certain procedure. And it's just for this one time. No, this is an ongoing legislative ordinance. So it is now in your hands. And I would also like to reiterate that, to draw your attention to 9.2 again. If you read the first note, if you read sub 8, it says, city ordinances or resolutions adopted under this section shall not be subject to the veto power of the mayor. It also goes on to say, under case law, the first item under the case law, a common council has no authority to make an initial judgment as to the constitutionality or validity of the proposed direct legislation. So in reference to Mr. Kalen's comment about how he doesn't understand how this pertains to us, it doesn't matter whether you understand if it pertains. The simple fact of the matter is you have two choices by state law. The state law says, under sub 4 of 920, the common council or village board shall, without alteration, pass the ordinance or resolution within 30 days following the date of the clerk's first certificate. Within 30 days. He goes up, get that certificate, brings it back down, you can pass it. That's within 30 days. And it should have been presented to you a long time ago. Now, once that is presented, one second, shall either, okay, I'm going to go back because I already read this, shall either pass the ordinance or resolution. You can pass the ordinance or resolution, or you can put it up for referendum in the next spring or general election. That's it. Those are your two choices. Unless, of course, it's administrative in nature, which it's not, as the case law clearly demonstrates. So I would be happy to read further into this case law, or I can email any of you that are interested a link to this case law. Now, in terms of whether this was meant to apply to the city or whether it was meant to apply on a broader spectrum, well, I can tell you, when I campaigned in this very council chamber, I spoke before you. And I've got on my computer, MP4, I got right to the section where I talked about this legislation. And I'd be happy to play it for you, where it clearly says that this will apply to local level officials, that a mayor will not be able to accept campaign contributions from people outside the city or an alderman from outside their ward. This is not something that has been fabricated at the last minute. This was the case all along. As a matter of fact, I have other evidence. I've got a video clip where I spoke to the City of New London Council, same thing, said the same thing. I've got a video clip of when I debated Kevin Peterson in my race for state assembly, where I said the very same thing. I've been consistent on this from the beginning. I have a copy here of a Facebook post dated September 4th, way back in the, before we started collecting these petitions, where I went on to say that if a referendum passes, the legislation becomes a local ordinance that pertains to local municipal offices, such as village presidents, trustees, and city mayors, alderpersons. There's also an article that was published in the Waupaca County Post that was dated October 11th. And the article says, as Martin and his campaign volunteers go door to door, they are promoting his candidacy and circulating petitions that would limit city and village candidates to accepting donations only from the people they represent. That was clear to people as I went door to door. I've got another email that I sent out to 413 recipients, basically saying the same thing, again, local candidates. And then, I don't know if any of you saw our petition tables that were set out on polling day, election day, but there were 2 posters on top of that table that explain what this legislation's all about. And you can't see it in this picture, these 2 little posters, but I got right here too. And you could read it if you really pay attention. But what it says is, this petition is for legislation that allows candidates for local elected office to accept contributions only from their constituents. The evidence is clear. This has been the intent of it. This has been what people were told as they were signing. This is what you have been told. I think it's time for Mr. Veliker to follow the state statutes and certify this. And then it's up to the council to vote on this, whether you want to pass it as an ordinance or whether you want to put it up on the ballot. Or under what grounds I can't fathom to understand, take some sort of position that this is administrative instead of legislative. But if that's the case, then this is going to go to court. And this is just going to get dragged on. But
John,
I can tell you 5 other
okay,
municipalities that pass
Okay,
this.
stop. Okay. John, you've listened to Mr. Martin speak. Has that changed your view on anything that you've said so far?
I think Mr. Martin has a narrow view of what the word sufficient means and what Henry's job is. But Henry made a determination that this was not sufficient based on advice he got from me and from other individuals. He also determined that while Mr. Martin campaigned on a specific subject, he did not document that specific subject well enough in this proposed ordinance for the city to act on it, because he didn't put in city officials, which he claims was his campaign. He put in elected office, which is way broader than what he was telling people. So I don't believe that he has drafted this ordinance in accordance with what he says his position was to the people he talked to and what he's telling us tonight. And for that reason, it's not sufficient. We can't act on it. We haven't authority to act on it, because we can't make an ordinance that has anything that has to do with contributions of elected office. There's a whole lot of elected offices that go on our ballots besides just the city, and he did not make it definite, which makes this insufficient for this council to act on.
So, Henry, you didn't certify it, and it was because of the recommendation of the city attorney and also others that you have talked to. Have you changed your mind on whether it should be certified or not?
I haven't.
And I would point out that the statute does specifically indicate that the clerk makes the determination as to whether it's sufficient.
Sufficient is the number of signatures and whether those signatures have expired and whether the people that sign that live within the city. That
Well,
is
let me give you an
sufficiency.
example about sufficient. It is very obvious that the city would not be able to pass an ordinance that governed murder. Pretty straightforward. That's a criminal law. City has absolutely no authority to enact criminal laws and penalties therefore. It's all state run. Now, this isn't a murder statute, but it is a statute. If he proposed a murder statute, it would be deemed insufficient. And that's all Henry did. He deemed this to be insufficient. He deemed it to be sufficient in regards to the number of individuals that signed it, but what he's asking for the nuts and bolts of the ordinance is not sufficient because we have no authority to enact an ordinance of this nature.
If we want to throw around
And that's all I'm saying.
analogies,
Hold on.
That's all I'm saying is that it's not sufficient. It is sufficient in a couple of different things, a couple of things, he's correct, but it's not sufficient in the content of what he's asking the council to do. You have no authority to act on a ordinance of this nature.
Okay.
if we're going to throw on analogies, well, order is a little extreme. Let's talk about building codes. The state has dwelling codes, but the city can impose even stricter limits that build upon state codes.
And the
city
state
can go
codes
beyond the
provide
state
that the
codes.
city can make more restrictive ordinances. The state law does not make, and does not say that the cities or municipalities can make changes in state law that's more restrictive than the state campaign financing laws. It does allow ordinances in the nature of zoning and various other things to be more restrictive if the council so decides. And I would point out, in that respect, he can't come in and propose an ordinance on our zoning code to make it more restrictive, because that's administrative. It's not legislative. And that's what he's doing here. He's asking us to change the state law that we follow,
It's not temporary.
which is basically administrative. It's a decision that we would have to make, not someone to propose additional legislation to change the state law.
Well, apparently the administrator of the Wisconsin Elections Commission disagrees with that, and a number of other attorneys have differences in opinion. I'd also like to point out that Mr. Hart has given poor legal advice to Henry and encouraged him to violate the state statute by acting beyond his authority.
Mr. Martin has given you poor advice by advising you to violate the open meetings law by going upstairs and certifying that petition and coming down and acting on it. And I told you, you can't do that. That would be a very serious violation of the open meeting law.
So, the intention of the meeting was to give the ability to Mr. Martin to tell us his thoughts on this ordinance proposal and to get the opinion of both our city clerk and Mr. Hart and our city attorney. And we've gotten that. And as Mr. Hart has said, the agenda is not appropriate to act on the certification, even if Mr. Belliker was to certify this, and I'm just saying what Mr. Hart has told us just now, is that even if Mr. Belliker was to certify this, we would not be able to act on it tonight. Anyways. So, I guess you're all looking at me, but I guess basically, from what I see, and you correct me, what I see is that we cannot force our city clerk to certify something if he doesn't believe it's correct. Am I right there?
It's not true.
Yes.
We cannot force him to, or we can.
You have an obligation under the state statutes to make sure that all the officers follow the state statutes under your command.
No, the council doesn't do that. Mr. Martin does that by bringing a writ to the court and have the court instruct Mr. Belliker to certify it. That's a whole different ball of wax. The council does not tell him what to do if the statute provides that he's to make that determination. I believe that this is more informational for council's purposes, so you understand what Mr. Belliker did and why he did it, and not to tell him how to do his job.
So, if the council disagrees, and you keep saying the mayor, but the mayor doesn't have the final decision, the council has the final decision. So if council thinks that, well, let's put it this way, that the clerk is not certifying it, and the council doesn't convince the clerk to certify it, you know, we can't make him certify it, from what I understand. Okay, so where are we then? Now, it is, one thing, please.
We've heard from Mr. Hart, we've heard the other side of the story. I don't, there's nothing, we can't take any action. What is there left to do? There really isn't anything left to do at this point.
But the only thing that we can do is that we can plan to do something in the future. That's the only thing that we could do if we decided to do that. And I guess that was the point I was going to make. So, I don't think there's anything against us doing our own ordinance if we wanted to on this same subject.
Yeah, if you wanted to, if you want to sit down and write an ordinance that would be legal for you to adopt, that'd be true. You could certainly do that. You could take that up with staff and decide how you want to do it, and make a determination as to whether that is worth the effort for you to do that sort of thing. And you might also want to embellish on administration of that ordinance as to how it's going to be enforced, who does the enforcement, and what information is necessary for elected city officials they have to provide to the council regarding their campaign sourcing. That's not in here, but that would be something that if you wanted to do that, I suppose you could. Not sure what the point is, but that's not what's up for discussion tonight.
Okay. Okay. So if we did want to discuss it at a future date, we certainly could do that.
Absolutely.
And put it on an agenda for a future date.
I think that would be appropriate. I think I'm one of those 409 signatures, by the way. I do believe, and I'm happy to say that, but I also see I don't want it to go to, I want it to go to referendum, not by city ordinance. I want the people to vote on it as a larger group rather than just 10 of us. I think, and so I know that would put it off till October. The statute says spring or general election. Doesn't say the next election. Well, if you want to get it for the next election, it's going to be done by Wednesday, obviously. So we're not going to get that. There's no way. But I would like to see if something we could be done, and maybe get a referendum put together in plenty of time for the October one, or November.
If I may just point out that State Statute 6209, Sub 8, says, "The mayor shall be the chief executive officer. The mayor shall take care that city ordinances and state laws are observed and enforced, and that all city officers and employees discharge their duties." So you do have the right to make Henry Velker finish that certificate and present it.
That's not true. Mr. Velker did his job by not certifying it and advising Mr. Martin accordingly. He didn't just not do anything. He didn't throw it in the garbage can. That would be something the mayor would take up, because he didn't do his job. He has done his job the way he feels it should be done, and he made a decision, and that is doing his job. The mayor doesn't have any right to tell him what decision.
You don't get the option of doing your job as you see fit. You do your job as the ordinances stipulate. It doesn't matter if he thought he was doing his job. If he wasn't doing his job, that's what matters.
Then you get the judge to tell him differently, because he made a decision, and you have an opinion, and he has an opinion.
And I alerted him to the deadlines well in advance.
I understand he made a decision. That's just how it is, and he did his job.
Dimitri, your ultimate goal is to either have the council vote on this or to put it up for referendum, right?
Correct.
Okay? So it doesn't necessarily have to be your ordinance.
I don't care. I
Yeah.
mean, as long as the people are fine with it, this really isn't even just about me. This is about the citizens, the 300 and, what was it?
409.
Well, originally submitted,
Yeah.
and then 300 and something were actual valids.
Okay, so we have one council member that asked that we discuss this at a future council meeting. And as we've done, whether it was a council member or a citizen, if they've asked for it to be discussed at the council level, we will do that in the future.
Okay.
So, I would ask, I guess, that it's not being certified by our clerk, and we're being advised that he will not certify it, and our city attorney is advising us that there's nothing we can do about that. Let us try and have a full discussion at the council level in the future, and it will be brought up. Now, whether it's recommended, what Mr. Peterson has asked for, that it be go to referendum, or whether council decides to vote on it, or whether council decides to do nothing, that will be the council's decision in the future.
Mhm.
But that's what I'm asking you to do. So, and that's what I'm asking council to do tonight, too. I don't know that we have any other things that we can do. Any other council members that would like to make a point or ask a question? If you'd like to be included in on a future discussion, let us know. Let the clerk's office know.
I would, yeah.
Make sure that you're put on that agenda.
If it's possible to get any notes, I understand there were some notes circulated that I didn't receive ahead of time, so maybe next meeting if I could get copies of that, that'd be nice.
Which notes are you talking about?
Apparently Mr. Hart circulated memo.
No, I did not.
Dimitri, it's on the website under, it's in the packet
Okay,
that they received.
The minutes will also end up on our website too, and we've been taping this the whole time. Plus, I'm assuming, Chris,
We're filming it.
yeah, it's also
radio.
on the radio too tonight.
sure.
You have all of those options,
Excellent.
okay? Anything else, council?
Move to adjourn.
Second?
Motion by Hagan, second by Keelan, that we adjourn this special meeting till our next regular scheduled meeting. Any discussion? All in favor signify by saying aye.
Aye.
Against? Motion carried. We're adjourned at 6:19 PM. Thanks, everybody. Have a great night.
Thank you.